There's a check most veteran families depend on for decades, and the day the veteran dies, it stops. Not reduced, not delayed, gone. But almost nobody realizes there's a second separate benefit built specifically to catch the spouse left behind. And most families never file for it. I am no expert, but on this channel, every week, I break down the real financial information that affects seniors directly, the rules that change, the protections you already qualify for, and the steps that actually move the needle. That's exactly the kind of thing you'll find here every single week. So if that's useful to you, go ahead and hit subscribe and turn on notifications now. Let's get into it. Here's the part that catches families completely off guard. VA disability compensation is paid to the veteran for the veteran's service-connected conditions. It was never designed to roll over to a spouse, and it doesn't pause or phase out. It simply ends the month the veteran passes. If that were the entire story, a lot of households would go from financially stable to scrambling almost overnight. But Congress set up a completely separate program precisely so that doesn't happen, and understanding the difference between the two is the whole ball game. That separate benefit is called Dependency and Indemnity Compensation, or DIC. It's a flat, tax-free monthly payment made directly to the surviving spouse, and it isn't tied to the veteran's rank or pay grade the way active duty or retirement pay would be. In 2026, the base DIC rate for a surviving spouse sits at $1,690.36 a month. A private and a colonel's widow receive the exact same base amount. That works out to just over $20,000 a year, untaxed, for as long as the surviving spouse doesn't remarry before age 57. And that base number is really just the floor. There are add-ons attached to DIC that a surprising number of eligible families never claim simply because nobody told them these exist. The first is called the 8-year provision. If the veteran was rated 100% disabled for the 8 continuous years immediately before death, and the couple was married throughout that whole stretch, the VA adds roughly $360 a month on top of the base rate. The second is aid and attendance, which applies when the surviving spouse needs help with daily living due to age or illness. That adds around $420 a month. The third applies to families with dependent children under 18 still in the home. DIC adds close to $420 a month per child, plus a temporary increase during the first 2 years after the veteran's death. Put together, a surviving spouse who qualifies for even one of these add-ons can see DIC climb well past $2,000 a month, or close to $25,000 a year, tax-free for life. For a lot of households, that's the difference between keeping the house and having to sell it. But none of it arrives automatically. Every dollar of it has to be claimed. So who actually qualifies? There are 2 separate paths, and the spouse only needs to qualify under one of them. The first path is the one most people already picture. If the veteran dies of a service-connected condition, meaning the disability the VA already rated, or something that condition directly caused, the surviving spouse qualifies for DIC. That's straightforward, and it's the scenario most families assume applies to them, if it applies at all. The second path is the one that gets missed constantly, and it's arguably the more important one to understand. It's known as the 10-year rule. If the veteran was rated totally disabled, either 100% scheduler or paid at the 100% rate through TDIU, individual unemployability, continuously for at least 10 years before death, the surviving spouse can receive DIC even if the cause of death has nothing to do with military service. A stroke, an accident, ordinary old age, none of it matters. 10 years at a total rating is enough on its own. This is why the date a veteran reaches 100% or TDIU matters so much more than most people realize. It's not just a compensation milestone. It's the start of a 10-year countdown that, once it completes, permanently protects a spouse regardless of what eventually happens. Every year spent at that total rating is a year closer to locking that protection in. Think about how often this quietly gets missed. A veteran rated 100% for 12 years dies in a car accident that has nothing to do with his service. His widow assumes the VA owes her nothing because the crash wasn't service-connected. She's wrong. Because of the 10-year rule, she still qualifies for DIC in full. There are surviving spouses out there right now who never filed simply because they assumed the cause of death disqualified them. It didn't. There's also a piece of genuinely good news here, and it's fairly recent. Veterans who retired from the military and paid into the Survivor Benefit Plan, SBP, used to run into what families nicknamed the widow's tax. If a spouse was owed both SBP and DIC, the government subtracted one from the other. Dollar for dollar, which costs surviving spouses thousands of dollars a year. That offset is gone. As of January 2023, a surviving spouse can receive the full SBP annuity and the full DIC payment at the same time, with no reduction. If your family was told years ago that these two benefits cancel each other out, that information is outdated. It's worth having someone check. So here's what I want you to do. The benefits, the discounts, the assistance programs most seniors and veteran families qualify for but never actually use. I gathered them all in one place, organized by state and by program, so you're not stuck digging through confusing government websites for hours trying to piece it together yourself. It's quick, it's straightforward, and is built so any senior or veteran family can find exactly what applies to their situation. No matter what state you're in, there's almost certainly help sitting on the table that nobody's told you about. It's called the Senior Exemption Playbook and is pinned in the first comment right under this video. Just tap it once and everything's laid out for you. Now stick around, because the last thing I'm covering is the one form that actually unlocks all of this, the single piece of paperwork that turns everything I just walked through from something you're theoretically owed into a check that actually shows up. DIC is also rarely the only thing attached to a veteran's rating. Several other benefits ride alongside it, and they're worth knowing about even if DIC itself feels far off. If the veteran was rated permanent in total, the surviving spouse typically keeps eligibility for CHAMPVA, the VA's healthcare program for dependents, which means medical costs don't suddenly become a second crisis on top of losing income. Dependent children may qualify for Chapter 35, the Survivors and Dependents Education Assistance Program, which helps cover college costs. Some families also have the option to compare that against the Fry Scholarship under Chapter 33, which in certain cases offers a stronger education benefit. It's worth having someone check which one actually pays out more for a given family, since they aren't automatically the same value. Eligibility for the VA Home Loan Guarantee can continue for the surviving spouse as well. And burial benefits are part of the package too, including possible interment in a national cemetery and a government-furnished headstone or marker at no cost, along with a burial allowance that can help offset funeral expenses. Now, a fair and important caveat: not every spouse qualifies for DIC. If the veteran didn't die of a service-connected condition and never reached that 10-year window at a total rating, DIC simply may not apply. That doesn't mean nothing is available. There's a separate needs-based program called the Survivor's Pension, meant for the surviving spouse of a wartime veteran whose income and assets fall under a set limit. It typically pays less than DIC, and not every household clears the income test, but for a lower income surviving spouse, it can still be a meaningful monthly amount. Here's the convenient part: the same form covers both programs. A surviving spouse files once on VA Form 2, 1P, 534EZ, the application for DIC, survivor's pension, and the VA evaluates the household against both programs from that single application. Nobody should assume there's nothing available until that one form has actually been submitted and reviewed. Along with the form, a surviving spouse will generally need a copy of the death certificate, the marriage certificate, and the veteran's VA decision documents showing the disability rating and the dates it was in effect. That last piece is exactly why it's worth keeping those papers somewhere a spouse can actually find them, rather than scattered across old filing cabinets or known only to the veteran. Timing matters more than people expect. If a surviving spouse files within 1 year of the veteran's death, DIC is paid retroactively back to the first day of the month the veteran passed, so there's no gap in income. File later than that, and months of benefits the family was entitled to can simply be lost permanently. One form, filed on time with the right documents ready, is genuinely the difference between full back pay and money that's gone for good. A couple of related things worth knowing while we're on this topic. There's also a version of DIC available to dependent parents of a veteran in certain low-income situations, which is separate from the spousal benefit and calculated differently, so it's not something to assume works the same way. And in recent years, expanded presumptive conditions under newer veterans' health legislation have made more veterans eligible for a 100% rating than before, which means more surviving spouses may end up qualifying under either path than families originally assumed. It's worth revisiting an old denial or an old rating decision if circumstances have changed. If a DIC claim does get denied, it isn't necessarily the final word. There's a formal appeals process, and an accredited veteran service officer can walk a family through it at no cost. VSOs are trained specifically for this and don't charge for their help, which is worth knowing before anyone considers paying a private company to file a claim. So here's the practical version of everything above, boiled down to a short list. If a veteran isn't yet at 100% or TDIU and believes the rating should be higher, pursuing that now matters because it's what starts the 10-year clock. If a veteran is already at 100% or TDIU, knowing the exact effective date and protecting that rating going forward is worth treating as seriously as any other piece of estate planning. Keeping the VA award letter, the marriage certificate, and a note referencing DIC in Form 21P. 534EZ somewhere a spouse will actually find them costs almost nothing now and can be worth tens of thousands of dollars later. And for military retirees, it's worth double-checking that SBP and DIC are actually being coordinated correctly under the current rules, since the old offset is gone, but not every household has had that corrected yet. The short version, the VA disability check ends the day the veteran does, but DIC can continue for the surviving spouse, tax-free, starting at $1,699.36 a month in 2026 and higher with the add-ons. Qualification comes through either a service-connected death or, just as often missed, 10 continuous years at a total disability rating, regardless of cause. The old SBP-DIC offset no longer applies. CHAMPVA, education benefits, and burial benefits often ride alongside it. And all of it comes down to one form, filed within a year, with the right paperwork ready to go. This is general education, not legal or financial advice. And it isn't coming from anyone affiliated with the VA. Survivor benefit rules have exceptions, so it's worth confirming a family's specific situation directly through va.gov or with an accredited veteran service officer, who can help file this at no charge.